I'm so sorry. Sorry, it's my fault. It's one of my fault. So sorry. Oh gosh. That's.
Be another reason why paper should
I
end.
think that I'm a new card, but it's one of these warnings. Okay, so I'll just make all these. Oh. Okay. So sorry.
No worries.
Transition to our culture. Ship has sailed.
Yeah. Transition will be when it's over. Retiring.
Alright, so we are ready. Are we ready? Are we? So sorry about this.
Don't worry.
Don't worry.
Court rise of fable. This is an appeal in the matter of refugee and migrant forum and Tuesday, November 12.
Yes. Well, Mr. Malik and Ms. Harrison, it's been very good to see you. Sorry about the slight delay, but we had to reorganise things with a certain rearrangement, as you could see, following on various things. So we're very grateful to you for the extra written work that you've helped us, provided us with. We think there's a slight issue with the bundles. So, Mr. Malik, what do you think we should have in terms of bundles and be looking for? Have it at our fingertips. What would you like us to have?
Yes, there is an additional bundle that was prepared for this particular hearing.
When you say bundle, what is it? A bundle of authorities or a bundle of?
No, it is a bundle that has an authority as well, but it has all the papers that you need for this hearing.
Okay.
Just to be clear about this, is one with 20 tabs. Starts with our decision
Yes.
in the previous hearing,
Yes.
and the only other authority is DM,
Yeah.
which has been put in at the end.
Yes.
And the rest is correspondence and your submissions.
Yes.
Right. Well, I don't think I've got that on paper, have I?
You have some, yeah.
I've got it somewhere, but I haven't got it here.
We
Well,
have.
rather than look for it. Was it sent electronically? Mr. Malik?
Yes.
Oh, I think parts of it are the submission.
When was it sent?
You may have an additional.
Both. It was sent electronically and hard copy last week. And on Tuesday, I think.
It was served by. We served it.
We served.
Yeah, the respondents served it last Tuesday, both hard copy and electronic.
Just a moment,
There's a chair drama going on here.
So Nicholas is experiencing what many of us are experiencing.
Yes, I
Yeah.
have a chair over the
Yes.
years. Spoiled for many years. My chair's always worked.
All right. So Ms. Harrison, say again.
Sorry, so on the respondents served the additional bundle on Tuesday, last Tuesday, both hard copy and electronic. If it isn't immediately available, Miss Lou can send it electronically again, if that would be of assistance.
I think I would ask her, Ms. Lou, could you send it to Miss Whitby, my clerk, and then forward it instantly to me?
Yeah.
Can you do that? Because I can't find electronic at the moment. I can't find it. And although I'm told it was delivered to me.
I suppose it's another reason why we should be ending this paper, but it's a transition that hasn't yet achieved, certainly from my point of view.
It's certainly could I say, the fault must be, the fault is my fault, and certainly it's no fault of those who sit behind you, who obviously prepared this case very thoroughly and well.
Thank you.
All right, so, Ms. Beale, if you could send that to Miss Whitby, there's no need to wait, we'll carry on.
I just raised this one possibility, which is we have a hard copy bundle but some of but on the submissions it's been marked. If you wanted to take them out, you could have that.
I've got the submissions and other.
You've got that in
documents,
another.
So I'm all right on that. But we needn't wait, we can carry on.
If you want to take that out.
Okay, yes, now, Mr. Malik. So as I said, thank you for your submissions. We'd like to hear your submissions, Ms. Harrison's submissions, and then you reply.
So in the light of the written submissions made by the respondents, what I'm supposed to do, subject of course to any observations, is to first address you very briefly on the law. I will then make some brief submissions on the scope of the judicial review claim and the scope of this appeal. And finally, I will make some submissions as to the engagement of Section 55 in the context of the decision making in this appeal.
Thank you.
So law first. In my respective submission, the law that is relevant to this appeal is now summarized in DN.
Yes.
Now I, of course, appreciate a lot that you do not have a copy of.
Well,
you have DM.
I don't, but I can easily access it. Can you just give me the neutral citation number, please?
2025.
Yes.
EWCA.
Yes.
Civ 1273.
Yes, that's right.
This is page 196 of the additional bundle.
Okay, I've got it on the Bailey. Okay, yeah, I've got. Yes.
Good.
Yeah.
The question as to the circumstances that would engage Section 55 is dealt with at paragraphs 106 and 107. And if you look at those paragraphs, this is page 228 and 229 of the additional bundle.
Yes.
In my respectful submission, 4 points arise from those paragraphs. The first point.
Are these the 4 points in your note, in which case I won't write them down, or you
Yes.
reformulate them slightly?
Those are the four points.
That's okay. But don't let me stop you, I was just writing my noting. Yep.
So those essentially are the 4 points. The first point is essentially line 4 of paragraph 106. The Secretary of State is not should not be regarded as discharging a function on every occasion. She declines to consider whether to change her policy.
I see why you're taking that's not the way the case has been put in this case here, is it? I mean that's not a central issue in that case. Yeah.
The second point, this is the middle
Miles
of,
now right, so yes.
so page 228 of that bundle law.
Thank you.
The second point is essentially the last 2 sentences at page 228. The Secretary of State is not required under Section 55 to review her policy from time to time, whether with regards to the best interests of the children or otherwise. The third point is in the final sentence of paragraph 106. The fact that the Secretary of State may, from time to time, confirm that she does not intend to change her policy cannot convert the maintenance of status quo into the discharge of a function within the meaning of Section 55.
It's really the same point as your first point, isn't it?
it could be a slight difference that isn't material as such. Yes.
The fact that she may from time to time confirm that she doesn't need change of term and condition doesn't convert all that into the discharge of a function in section 55.
Yes. And then finally, the fourth point, paragraph 107, last sentence. She will only be discharging a relevant function within the meaning of section 55 if she makes a decision not to change the policy as a result of a substantive review process. Earlier on in the paragraph, there is a reference to a process of substantive reconsideration that is pursuant to a formal process. What that means is identified at paragraph 103, where, for example, an official sets out various options. There is, for example, some consultation, and the Secretary of State then makes a decision. That is what Murad meant by substantive review. And in my submission, the legality of what has happened in these cases is to be judged against these four principles.
Just to go back to points 1 and 3, I suppose there might be a difference between 1 and 3. You know, one is describing something that the Secretary of State does internally, and 3 is describing something she does externally, i.e. communicating the affected one to the outside world.
Yes, there is a slight difference. Yeah, you're absolutely right, but it's not material because
No,
but
not
there are
material.
in my submission for these four things.
Just before we leave what DM decides, we do need to note that there were 2 cases advanced by the claimant. The original case, which we start dealing with at 92, which was squarely based on the very conventional thing. She made a decision that there are obviously what decision was made when, and just the points you've been looking at whether it's a decision when you say I'm not going to change my position. But then there was a new case run for the first time in the Court of Appeal,
Yes.
which is dealt with at starting at B, page 11232 in the bundle, para 119, and that was that it wasn't pinned on a decision, it was simply pinned on the operation of the overall system. As to that, we, in the end, although we made some sceptical noises about that way of putting it, we didn't finally decide it. That's, as we see at 128. And we went on and decided on the narrower basis that the Secretary of State did in fact, was in fact under an obligation as soon as the Act came in, and she had never discharged it because she was deciding whether or not to, as an obligation to decide was created by the Act coming into force. And that's, so the whole picture of DM that is slightly broader than your 4 points. Now, I'm not sure that's material.
Yes.
But I just wanted to get that out there in case anyone wants to say anything about it.
Well, I'm grateful. So the point that wasn't decisively decided in DM, is not a point that in my submission the court is required to decide in this appeal.
No.
And if a point is made by Milan and friends on the other side, I will reply to it.
I haven't detected it in the written submissions.
Right.
So this is DM laws. So if I may then quickly move on to the scope of the judicial review and the appeal. Now, what this judicial review claim was about if you have the core bundle,
Yes.
may I take you to page 357. So this is the judicial review claim form. Lords, you have picked the point already in the judgment. But if I may ask you respectfully to look at a part of that claim form that appears at page 364. This is section 3 of the claim form, where Ramphel sets out the details of the decision that they were seeking to judicially review. And if you look at the second paragraph in box 3.1, you see that the challenge was to the Secretary of State's ongoing breaches to section 55 of the 2009 Act. And if you look at section 3.2 of the claim form, you'll see that no date of decision is given, and what is said is that the breach is ongoing. Now, in that context, if you then turn to the grounds of judicial review, this is page 375. Paragraphs 1 to 9 are essentially a preamble to the pleadings. And if you look at paragraph 9, you see the context, the precise context in which the grounds are pleaded. There is a reference to Windrush scheme, and it is stated that the Secretary of State has not carried out any necessary inquiries, monitoring, or evaluation to ascertain and assess whether or to the extent to which other undocumented lawful migrants, those who are in Section 3C leave, are also exposed to and suffer serious harm from hostile environment measures. Instead, the Secretary of State denies that she owes a duty of inquiry. Now, this is the context in which then 4 grounds are pleaded. And if you look at the 4th ground, the ground is that the Secretary of State has breached Section 55. Now, may I then take you to paragraph 96 of 94 of that document, page 406 of the bundle. You see heading ground 4, breach of section 55 of the 2009 Act, and you'll see how the case is put. Secretary of State.
Wants to read, just remind ourselves of paragraph 94.
Paragraph 94.
Should we read that? Just remind ourselves of that.
Yes, please.
Thank you.
Paragraph 94. The essential point is that the Secretary of State is required to undertake a structured assessment of the impact of the immigration control policy on the welfare of the children. And what the Secretary of State should do is to identify the best interests, what the best interest of the child requires, ascertain whether to what extent the children are impacted. So essentially, the point that is made in the claim form, the point about conducting an inquiry and investigation. And then if you then read paragraph 96, the point is that the Secretary of State does not cannot lawfully discharge the duty if she does not even acknowledge the problem identified in the claim, and that it is said is breach of the duty. So there is fact plain that there is no challenge. There is no challenge to a particular policy. There is no challenge to a particular decision. The argument that was pleaded, as it appeared to me and to those who instructed me, was that as soon as applicants go on to Section 3C leave, the Secretary of State is obliged to conduct an inquiry as to the welfare of the children and impact on them of there being no documentary proof of their residence.
Maybe there's a broader point that's being made, which is that having investigated the Windrush matters, the Secretary of State should then have thought to herself, people on Section 3C leave who are lawfully here have a similar problem, and I ought to look into that.
Yes.
In a general way, rather than in each specific case.
Yes, precisely. So that is why, lady, I said as soon
I'm
as
sorry,
the
it's my
applicants,
fault, I misunderstood what you were saying.
as soon as the applicants generally go on Section 3C leave, that triggers a duty on the Secretary of State to conduct an inquiry, a broader inquiry.
How do you get that out of it? Surely, isn't an alternative reading, possibly a better reading, though it's all extremely vague, is that the claimant was operating a system, sorry, the Secretary of State was operating a system under which, whenever someone went on Section 3C, these disadvantages to children and others, but children, would arise. And before deciding to implement such a system, he should have carried out a Section 55 inquiry. And that's in a sense what the case became at a late stage during the hearing, when you, for the first time, accepted that there must have been a decision of some kind. We're going to look at that presently, I think. But might it not be said that's implicit, although it's very loosely spelled out, in the original claim?
I accept that, yes. So there is, I entirely accept a possible alternative reading of these paragraphs. What I'm seeking to submit, my lord, is that this is how we read the pleadings, and that explains the response to these pleadings in the detailed grounds of defense. But ultimately, in my submission, it does not matter. What really matters is how the judge understood the claim to be and what the judge decided.
Well, yes. Because you're like it may matter in the sense, at least of explaining where we are now.
Yes.
That you didn't, you understood it in the way you explained, but the claimants also didn't really focus on the need for a decision.
Yes.
And therefore didn't plead any particular decision, didn't ask for any information about how the decision was taken, didn't themselves put in any evidence about the system.
Yes.
In particular, as regards the introduction of e-visas, which all came from you, rather by a side wind.
Yes.
Anyway, I'm sorry, I'm getting ahead of myself, but these are points that interest me, and they don't really appear in any of the evidence except in the indirect way, and that's a reflection of the way the claimants chose to plead it.
Yes.
And the way you understood that pleading, right, you're wrongly.
Yes.
Yes, actually.
Now, for the purposes of the argument that I will make, what I do submit is that there is, even on that alternative reading, no challenge to the e-visa rollout.
Yeah.
There is no challenge to the 2021 policy document. And it is not suggested that the gradual rollout of e-visa is unlawful. It isn't pleaded or even suggested that in prioritizing certain routes in the gradual rollout, the Secretary of State has acted unlawfully.
Hang on a second.
Can we just go back a stage and just be clear about which decisions we're talking about? Initially, the Secretary of State's case was that when somebody goes on Section 3C leave, that happens automatically as a matter of law, and so the Secretary of State does not make an active decision to put somebody on Section 3C leave.
Yes.
So that's one area in which there is not a decision. It's important to be clear that there's a separate issue about whether or not, and if so when, the Secretary of State made a decision or decisions
Yes.
about the rollout of the
Yes.
visas. So it's important to keep those two things separate.
I agree, Lady, and I will of course address you on those issues.
Yeah, I just wanted to be sure I wasn't going astray.
Lady, you're not.
Can I just get one other thing clear in my mind? In one sense, the gradualness of the rollout, in the sense that it was done for different routes over a 2-year period, isn't really what is the potential target of challenge. Really what the claimants ought to be complaining about, and not clear they ever have been, this is your point, is that once you have a system of e-visas for migrants, even if you did it for all available routes on day one, that wouldn't benefit anyone who was on 3C leave.
Yes.
It only benefits them 2.5 years later, or however long later, when having already been given e-visas, they then go on 3C leave, and the benefits of digital demonstrability continues. If such a challenge had been clearly pleaded at the start, they could have said, well, look, what you ought to be doing now, sometime before late 2022, whenever these proceedings were started, you should have issued it to people on 3C leave.
Yes.
Which is a quite different kind of leave, but you could have worked out who those were and given them access to digital documentation. That's really what this is about. And the fact that the issue of the e-visas themselves to people with primary leave, on their applications for primary leave, is gradual, is a bit beside the point. It just means the problem goes on for longer. But the problem was there from the start. Until I'm slightly thinking aloud, I found this difficult when writing this part of the judgment, but I thought I'd got there. And I've been thinking about it again in the light of the further points made by the respondents. But that's really what it's about, isn't it? If there were a challenge, that's what it would have to be.
Look, I do not disagree with that at all. But the way I read the written submissions that have been made, there is now, you'll hear from a learned friend, but it appears to me that there is now a complaint about why particular routes were picked in the initial phase of the rollout, and why certain other routes were
Yes,
not picked.
I saw that, but that's really about it. That's at best a secondary complaint. It may make the problem worse,
Yes.
but as I said, the problem would have been there
Yes.
even if they'd done everybody from January, well, the start of January 2023 or whenever this came in.
Yes.
Because that wouldn't have helped the people who were already on 3C leave.
Yes.
Or indeed who came on the 3C leave in the course of the following 2 years.
Yes. So as I understand, Lord, the point that is now made, and you may of course have picked this from the submissions that 11 friends have made, that the Secretary of State has prioritized certain routes in phase 1 of the rollout. Not disagreeing with you, all I point out is that that isn't the point that was made. And for that reason, there wasn't any evidence from the Secretary of State or response to that argument. As to why route X was the first route that was picked as opposed to route Y. Why route Y was the second or the last route in the rollout. And then
Can I just ask one other point?
Yes.
Then I'll shut up. Just get this so clear in my mind. It now appears, which I hadn't appreciated during the hearing, and I think conveniently because we hadn't got materials in front of us, that although the initial policy was only to give e-visas to people on at the moment that they were given a fresh right to leave, at some point during 23-24, there began to be a policy of making e-visas availability to people, e-visas available to people who at the moment only had BRPs.
yes.
They could, as it were, convert them into e-visas. And that becomes clear for, I think, some of the documentation from 2024, which is in the new bundle, which wasn't for us. But that doesn't really affect the point in principle, because it just reinforces the point I made earlier. The real complaint is, whatever may have been done to people who had primary leave, it wasn't done to people who were on 3C leave. Yeah.
Yes.
Okay, thank you. I just want to, but that is right, isn't it? That I was technically, I think, wrong, though not in a way that mattered, in my recitation of the facts in my judgment, in suggesting that you, throughout this relevant period, you only got e-visas at the start of a period of leave.
Yes.
At some point, that was modified, and you could actually get it in the currency of a period of primary leave. Have I got that right?
Yes.
Yes.
Yes. Thank you. I don't think that matters, but I want to make sure I haven't made a muddle about it.
Again,
Thank you. I'll now keep quiet.
You hear, of course, from 11 friends, but it seemed to me that they're making these 2 points, Lord, the point that you identified, and then the point about prioritizing of certain
Yes.
routes. Now, may I then, that this explains the defense that was put forward. We understood this to be the argument that I just summarized, that once one goes on to Section 3C leave, generally it triggers a duty of investigation and inquiry, and the point was made in the defense that the extension of leave is automatic, and when someone or a group of individuals go on to Section 3C leave, it is not pursuant to any action or function of the Secretary of State, it is all automatic. May I then show you what the judge has decided and what is the issue in this appeal. So if you go to page 408 of the bundle, the core bundle.
The order.
The order, yes. Paragraph 2 of the order. In failing to provide the said digital document, the defendant has also acted unlawfully in breach of Section 55. So the judge's declaration does not relate to a particular policy or a particular decision. It is not said that a policy or a decision is unlawful. The declaration is that in failing that there is a failure by the Secretary of State to provide digital documents to all those who are in Section 3C, and that failure is a breach of Section 55. Lady and Lords, you have, of course, seen the judge's judgment. But may I just take you to that judgment again, just to make one further point before I make submissions on engagement of Section 55. And that is paragraph 250 of the judge's judgment.
Page 165.
Page 165, yes, I'm very grateful. Sorry, my apologies. So if you look at page 164 first and see how the claim was put to the judge. On behalf of the claimants, this is paragraph 247. On behalf of the claimants, the argument was that in making arrangements to give effect to the statutory protection under Section 3C, the Secretary of State is required under Section 55 to investigate whether and to what extent make people undocumented during the period of Section 3C leave impacts on the children. So even at the hearing, there wasn't, in my respective submission, a challenge to a particular policy or a particular decision. The point was that under Section 55 there is a duty to investigate, and the failure to conduct that investigation is unlawful under Section 55. And this is the submission that, in my submission, the judge ultimately accepts that paragraph 250. Middle of that paragraph, I agree with the claimants. So the judge is agreeing with what the submission is at 247, that the failure to provide documentary proof might have an adverse impact on the children. The Secretary of State gave no consideration to this matter, and that puts the Secretary of State in breach of Section 55.
Paragraph 248 may be relevant as well,
It is.
because in that paragraph he sets out your client's original position that there's no decision involved in relation to Section 55. But then he goes on to he sort of elides that with, in deciding not to provide documentary proof to all those on Section 3C. So there's a movement from one thing to another.
Yes. So the reason why I skipped over paragraph 248.
Sorry, I'm sorry if I've taken.
No, because of course I appreciate what is said in that paragraph.
Well, just take. You're going to make a submission.
Of course, that essentially was the third part of my submission.
Okay,
all right, all right. Well, as you'll appreciate, Mr. Marek, I'm sitting with the red hot experts in this, so it would help me if you could just develop that point a little more, with a little more detail for the slowest ship in the convoy, which is me.
Yes, at this stage.
There you go.
Yeah, I will, of course, yes. So, but the submission that I'm making here is that the claimant's submission is at 247. That is a submission that is
Accepted by Mr. Justice Cameron at 250.
Yes. Now, the judge isn't saying that a particular policy is unlawful or a particular decision is unlawful, and there is no respondent's notice. The respondents are not saying that this court should upheld the judge's decision on some other ground.
I agree that even this isn't quite how it's put, but implicit in the way it's put is a particular state of affairs is unlawful.
Yes. Yes, a particular state of affairs is unlawful because the Secretary of State has not investigated the impact.
Yes, but it's a state of affairs for which the Secretary of State is responsible is unlawful. That's what lies behind it, isn't it?
Yes.
A failure rise to the alleged adverse impact.
And the reason, Yes, I agree, and the reason why that is so is because the Secretary of State has not investigated the impact of that state of affair on the children, and she hasn't given consideration to the welfare of the children. She hasn't investigated the matter, and that means that that state of affairs gives rise to a breach of Section 55. I do not have a problem with that reading of the judge's decision. The point for the present purpose is that there isn't a decision that the Secretary of State has in 2021 acted unlawfully when the 2021 policy paper was issued, or whenever the decision was taken to give effect to that policy by the gradual rollout that was unlawful. If I may then just move on to the final part of my submissions, addressing directly what the judge has said at paragraph 248. Lady Lords, the Secretary of State, I'll make three submissions, 3 short points. First, the Secretary of State has made no decision not to provide digital documentary proof of immigration status to all those who are on Section 3C leave.
Sorry, just give me that submission again.
The Secretary of State has made no decision. Secretary of State has made no decision, and then inverted commas, not to provide, these are the words that the judge has used, not to provide digital documentary proof to all those on Section 3C. In the 2021 policy paper.
So you're developing point 1 rather than going on to points
Yes.
1 and 2. Yeah. Okay.
So in the 2021 policy paper, this is the new plan for immigration, legal migration and border control policy paper. The Secretary of State set out a long-term vision to move away from providing physical documents evidencing immigration status and to enable all individuals to demonstrate their immigration status digitally. Now, that was the decision taken by the Secretary of State, and that was a policy decision.
Can I just make sure I've understood that? That is a policy decision to move to e-visas.
Yes.
Implicit in that is that when someone with an e-visa comes to the end of their period of primary leave, their 3C leave will be digitally demonstrable.
Yes.
On the e-visa. So that's why you say he didn't make the decision not to.
Yes.
But that's not inconsistent, and perhaps you're coming on to this, but in which case I apologise. That's not inconsistent with him or her having made a decision not to provide e-visas, digital demonstrability, to people on 3C leave immediately, or
Yes.
at the same time as giving it to people on primary leave. And the Secretary of State did make such a decision at some point.
Yes, but the decision that the Secretary of State took was one that I have identified, which was to provide a digital document to all applicants.
Yes, I see.
And of course, one effect of that decision was that not everyone will get a digital status immediately.
Yeah.
And it is, as I said in my written submissions, arguable, it's not a point that the court has to decide. It is arguable that the publication of the 2021 policy paper was an exercise of function under section 55. And therefore, in principle, there could be a challenge to the 2021 policy paper on the basis that that policy is in breach of section 55.
One second. Sorry, so your what you meant, your concession, if I can call it that, in the note is that it is arguable, though you say we don't have to decide it, arguable that what?
That the publication of the 2021 policy paper was an exercise of function under section 55 of the 2009 Act.
Yes. Why don't we have to decide that?
Because there was no challenge to that policy, and there is no challenge to that policy.
It's 4 years, 5 years.
Now, after that policy was published, the Secretary of State, as the court knows, rolled out e-visas gradually, route by route.
Are we now on to are we still on the first
Still
point?
on the first point, yes. Now, the gradual manner and the sequence of the rollout, by that I mean which routes went first, that is not recorded in any formal policy or decision.
Well, the fact that it was going to be gradual and the priority, two things weren't recorded. Either the fact it was going to be gradual or the priority to be given.
Now, the fact that it would be gradual, of course, was the whole point of the 2021
That goes
policy
back to
paper.
2021.
So that's what the decision was to roll out gradually.
Yes, in 2021.
Yes. But what wasn't?
But what wasn't was that the Secretary then rolled out e-visas, and the sequence of that rollout, and the manner of that sequence, namely which routes would go first. Now that is not recorded in any formal policy or decision.
Nevertheless, it must have been decided,
So
not necessarily by ministers.
my submission, my lord, is that the sequence of the rollout was simply a practical arrangement to give effect to the policy set out in the 2021 policy paper. It was simply a practical arrangement of giving effect to that policy.
And the officials who were doing that were bound by the guidance.
Yes. But that practical arrangement,
Well, are you, my lady's point, okay, goes to the heart of one of the points, assumes that those decisions were not taken by ministers. We don't actually know whether they were taken by ministers who would not be subject to guidance, or by civil servants who would be.
What do we know about? What do we know about how it was decided? How the sequence was decided? Anything?
so I have of course taken instructions, and the submission that I make is that there wasn't a formal written decision that was taken. it was a practical arrangement that was agreed. And that
Yeah, well, A, it's a bit dangerous to decide these things on instructions, and B,
Be totally unacceptable.
one would need to know a bit more about what you mean by no form of that. Clearly, a decision of some sort was had.
Yes.
Somebody must have said these routes and not those routes.
But we of course considered very carefully whether to put in further evidence
Yes.
before the court to explain that arrangement.
Yes.
Of course, our last attempt.
And you
to
were asked to.
Yes, but of course, our last attempt to provide the court with further information about the rollout wasn't successful, and
That's
the application to
ridiculous.
rely on.
It doesn't matter. You have decided not to give detailed evidence, which I'm sure would have had to be quite detailed, so I'm sure it wasn't
Yes.
straightforward, about how these decisions were made and who made them. You were encouraged to by a letter from the claimant solicitors, but
Yes.
you declined to.
No.
And we are where we are.
Yes.
But you would say, I think, that certainly no such evidence was before the judge.
No.
Because it had never crystallised as a problem.
So, of course, I appreciate, Murad, that you refer to what has happened as a decision.
Yes.
But whether it was a decision or someone coming up with a practical arrangement, as I put it.
Well, the practical arrangement, we all use decision as a shorthand. The word in the statute is the discharge of a function. It is the discharge. Deciding that routes 1 to 15 we'll give straight away, routes 15 to 16 to 27 we'll give in the spring. So that's an exercise of a function. Whether you call it or not, you call it a decision with a capital D.
Even if one takes that view, the reason why I took you to the pleadings and the judge's decision was to demonstrate that it was never argued by the other side that arrangement or the decision to make that arrangement was unlawful,
Yes.
and the judge has not decided so. And for this court to now decide in my submission the legality of that arrangement would convert this appeal into a judicial review claim. The court in my submission cannot possibly determine whether those arrangements were lawful or unlawful without proper pleadings, without an opportunity to the Secretary of State to put in evidence, but not this case.
Right. So all this is your first point.
Yes.
In reply to in observations about paragraph 248.
So the second point.
Yes.
Lord,
Second.
yeah. So the Secretary of State took the view that it was not possible to provide a meaningful physical document confirming Section 3C status to those who are on Section 3C leave.
Sorry.
Seriously, took
Took the view
a view.
that it was not possible to provide a meaningful physical document confirming Section 3C status to those who are on Section 3C leave. The Secretary of State also took the view that it was not possible to provide a digital document confirming Section 3C status to everyone at once instead of following a gradual program.
Sorry, isn't that blurring 2 points? As I tried to suggest earlier, gradual introduction of different routes is one thing. Deciding whether to grant digital documentation to people who are already on 3C leave
Yes.
is another.
Yes.
Secretary of State has clearly always taken the view that she, can't do that,
Yes.
but that benefit will simply accrue as a result of the gradual implementation of e-visas for people with primary leave.
Yes.
If I got that right.
That is absolutely right. Yes. Not that was the view that was communicated to the judge.
Yeah.
In the pleadings, in the witness statement of Jonathan Wright, and in the oral submissions.
Just show me where it is in the pleadings, because in a sense, you made the point yourself that Jonathan Wright was not primarily concerned with this point, because it wasn't the case he had to meet. He said what he said, and it's helpful to you, but is there something in the pleading saying effectively the same as what he said?
No, so the pleadings, of course, refer and rely on Jonathan Wright's witness statement.
Oh, I'd forgotten. Yes, I see.
Yes, and within that, there is that paragraph that Lord you picked and quoted in your judgment.
That was from the witness statement, though.
From the witness
not
statement.
from the pleadings.
From the witness statement, yes, where the point essentially was that it wasn't possible to provide a digital status retrospectively to those who were on Section 3C leave. But that is what was communicated to the judge, and in my submission, this is what the judge meant at paragraph 248. So he read that so to mean that the Secretary of State has decided not to provide documentary proof to all those who are on Section 3C leave.
So it's really, the judge misstated the rather more nuanced position that you were adopting.
Yes, I of course appreciate that it's all my fault. I may not have expressed myself in the right way, but at no point there was any evidence or submission that there was a decision that the Secretary of State has taken not to provide documentary proof to all those who are in Section 3C leave.
Well, what precisely do you challenge about the way the judge put it in Section 24, paragraph 248?
That there was never a decision not to provide documentary proof to all those who are in Section 3C leave.
There was no. So you should tell us that there was no decision not to provide documentary proof.
No.
To all those on Section 3C leave, and you don't accept that you accepted that, which is what it says you did. 248. So 248 says that you in the hearing before him accepted that it decided not to provide documentary proof to all those on 3C leave. You were exercising. He was exercising his ancillary administrative functions.
But he's running together two things, isn't it? Because your position was Section 3C. There is no decision involved in giving Section 3C leave to someone. That comes about as a matter of law. So that's one point we're making. And decisions about whether or not to provide documentary proof are a separate issue.
And I think building on that, the concession was aimed at a different point.
Yes.
What you were saying was essentially a preamble to the actual concession, which was that in taking decisions about the introduction of digital documentation generally, you were exercising your ancillary powers.
Yes.
And you were no longer saying this should happen automatically. You said obviously there was a function of some sort, and it was an intra vires function because of the ancillary powers.
Yes.
And that was really what most of the debate had been about up to that point, and you were saying you were no longer pressing that point.
Yes. And then of course the judge had the submissions that I essentially just made, that the Secretary of State had taken the view that she cannot provide either a physical or digital document to everyone on Section 3C leave. And the judge, in my submission, essentially read that as a concession or acceptance that there was a decision, a sort of positive decision not to provide documentary to all those who are in Section 3C.
But have I got this right? The reason why what he says is too broad, or what he misses is that the Secretary of State had made a decision to provide digital documentation in due course to everybody. The result, to everybody with primary leave, the result of which would be that when that primary leave expired, it would also be available to people on 3C leave.
Yes.
And it's a misstatement of that to say, I was never going to give it to people on 3C leave.
Yes.
It is, however, true that you were never going to give it to people who already had 3C leave. That's what Mr. Wright says, that would be too difficult.
Yes.
Have I got that right?
Yes. And that essentially is the second point. The final point on the list essentially was, Lady was that this gradual and staged rollout was the only realistic approach. It was simply not possible to issue e-visas to everyone at once. There was and there is no real scope for a different outcome or approach. The Secretary of State would have proceeded in the same manner, no matter what. And this is effectively what Jonathan Wright stated in the witness statement, that it wasn't possible to provide a digital document or e-visa retrospectively to everyone who is on Section 3CD.
And that was just a short, single sentence
A single sentence, yes.
in Mr. Wright's statement. Do you want just to, for the record, for my note, remind us exactly where that is?
Yes, so if you, that is of course if you have the additional bundle for this hearing,
Yes.
and if you look at page 21 of that bundle,
Sorry, page number again?
page 21, this is the judgment of this court,
Yes.
of course, given in November. And if you look at paragraph 60,
That passage
you'll see that.
cited by you.
Yes, and then see what the Lord has said about that. That in the context of the Secretary of State's announcement, the passage was clear enough that it wasn't possible to convert the existing graduate program into one which everyone is provided with a digital document who is on Section 3CD. So on the basis of these 3 points, I invite Lady in the laws to find that Section 55 is not engaged in the sense advanced by the respondents, either in the original pleadings or now before this court. As DM makes it plain, there is no duty under Section 55 on the Secretary of State to keep her policies under an ongoing review or to embark on an investigation or an inquiry when someone or a group of individuals would go on to Section 3CD. Secretary of State has issued, as the court knows, statutory guidance under Section 55. And the Secretary of State is obliged to follow that guidance whenever she makes a decision, whether that decision is in a particular phase or whether it's a policy decision. the judge's approach was wrong, and the judge's conclusion was wrong. And for these reasons, it wouldn't be appropriate in my submission for the court to convert this appeal into a judicial review claim against a decision that was taken in 2021, that is the decision to issue the 2021 policy paper, or the practical arrangement pursuant to that policy decision as to how to sequence certain routes and the manner of the gradual rollout. The judge's decision was wrong and the declaration was wrong, and I invite the court to set that declaration aside. Unless I can assist you in further, the other submissions.
Well, just to draw attention to one other point you made, which you mentioned partially as you went through. You have a separate point that a grant of relief would be futile.
Yes.
Because the evidence being what it is, and which the court accepted first time round, if the Secretary of State were, in fact, obliged now to conduct a Section 55 exercise according to the current state of affairs, she would not, there would be no different outcome, because as the evidence is, it was impossible to do it in any other way. And whether that is a general discretionary consideration or it can be fitted into the terms of Section 31(2)(a), I think you put it both ways. But that is part of your written submissions. I can see why you haven't identified them, why you haven't developed them here, but is that right?
My apologies. So that essentially is the third point that I made. That there is.
Oh, is it? I'm so sorry.
Yes, my apologies. Entirely my fault. So that really is the third point that I made. That there is no.
I hadn't seen it as that. Yeah.
Yes. So there's no realistic possibility of a different outcome, and that is the reason.
The only realistic.
Yes. Now, and
All right, but that first, there's a real difference between that and your point, the section and the other points, which all go to whether Section 55 was engaged.
Yes.
This point comes into a later stage where you say, well, suppose Section 55 was engaged.
This is not.
Then I think you are indifferencing on the facts because you've never suggested that there was a Section 55 consideration.
Yes.
In that sense. But for that position, no doubt,
yes,
it doesn't really, it doesn't justify any relief.
Yes. And yes.
Is that, have I got the structure right?
Yes. Yes. Now, the judge granted relief on Section 55. And this is the point that I've made in my written submissions. I'm not going to make any of these submissions. Essentially on the basis of his earlier findings, that it was possible for the Secretary of State
Yes.
to issue e-visas to everyone at once.
Right.
Now, if the judge had appreciated that that wasn't possible,
yeah,
the judge, in all likelihood, would have declined to grant relief under Section 55 as well. And that essentially is how I put it.
Okay.
Yeah. Thank you very much, Mr. Manning. Ms. Harrison.
My Lords, in response to Malone and Friends submissions, what I would intend to do, because it obviously has taken up quite a lot of the Malone and Friends submissions, is to look first at the pleadings so that we understand exactly what submissions were made and what the Secretary of State's response was.
Yes.
Then I will consider the new plan and how it was rolled out. The judge's findings on that and the implications of it. Obviously, we submit, as you've seen from our written submissions, that we say that the judgment at 250 is correct in law, that the real issue here is not so much that the claimants never pleaded a clear case, but rather that there has been a shifting sands of the case of the Secretary of State. So that's why I will deal firstly with the position as to the pleadings.
Yes.
The learned friend has taken you to the grounds in the Ramphel case. As you're aware, this is a consolidated appeal, so it makes sense to look at those. But I'd ask your lordships to take up at, it's in tab 29, page 376, how we put our case in summary
Just a moment. Let's
at paragraph 3.
Let's get it up. So we looked at part of this. So you want to take us to paragraph 3.
Yeah, because this in summary puts our case.
So page 364.
It's 376, my lord. It begins at 375. The detail grounds.
So you're on the grounds.
Yes, it's the pleadings in the Ramphel case.
Yes.
And paragraph 3 sets out our primary complaint. The Secretary of State does not provide people whose leave is extended by Section 3C with a document, whether hard copy or digital, to give effect to the statutory protections granted by Parliament and to enable this cohort to demonstrate their continuing lawful immigration status and rights. So we were complaining about the failure of the Secretary of State to make provision for those who are on 3C leave with a means of, or to make arrangements for and provision of, some form of proof of their lawful immigration status. And obviously we relied upon what is accepted to be substantial harm, significant difficulties and adverse consequences from what we described in paragraph 4 as a protection gap. And obviously prayed in aid the consequences that the court has understood and seen in paragraph 5 as to being wrongly subject to the hostile environment. So it was clear that our submission was, as is also, as my learned friend has shown you in the claim form, the ongoing failure of the Secretary of State to make provision for a form of proof, effective proof, except here digital proof, of their lawful immigration status to avoid being wrongly subject to all of the measures in the hostile environment provisions. That it wasn't Parliament's intention that they would be so subject.
Is any other part of the grounds of relevance to your specific claim under ground 4 under section 55?
Yes, Lord, I'm going to come to that, but and I'll do that as quickly as I can. Your Lordship, my Lordships have been shown that we had made reference to the Windrush scheme and the Windrush scandal, and identified as that there were other groups of individuals, lawful migrants, who are unable to establish their lawful status with serious adverse consequences. You've seen that paragraph at 9.
Just to go back to paragraph 3. To see whether I understood the legal submission. Is the premise of what's said in paragraph 3 that the Secretary of State is under a legal duty to enable people to prove their immigration status straight away? The submission was that the failure to provide that form of proof was unlawful because it was either irrational. No, but what's the legal foundation of that submission? It seems to me it must be based on a suggestion that the Secretary of State has a legal duty to provide these documents to these people.
Yes, the legal duty was on the basis that it was irrational not to do so, or it was a breach of the Padfield Arguments. I appreciate that we didn't succeed on that point now.
Do you spell out the duty in the claim?
Can I help on this? I think this is your irrationality. I mean, this was why it's slightly unhelpful to look at these introductory materials, because this is an omnium gathering cover. It's a background to the actual legal claims you go on to plead.
Well, but it's the sorry. Yes, of course.
I've always understood you did say there was a legal duty. That is your
Yes.
irrationality ground.
Yes.
However, that's water under the bridge.
Yes.
You've lost on that.
Yeah.
The real question here is a much narrower question about process.
Yes.
Whether in discharging a function, you can't work out from here what function you have in mind, the Secretary of State was obliged to carry out a Section 55 exercise.
Yes.
We won't find that here because you're to such a high level of generality here. You're not dealing with that point.
Well, but this is the foundation of our case. I'll show you how it
This is
was.
just a general intro.
But it's
Your
what.
legal foundation of your case must come in the pleaded grounds, which we come to much later in the document.
Well, that is I've got about an hour, so I'm now having to re-argue what the case
I think,
was.
Ms. Harrison, we ought to let you develop the argument as you wish. You've taken us to paragraph 3.
Yes.
And as my lord says, that sets the background. I've asked you specifically about the
I'm going to come to that.
Come to
Yes. I'm trying to do this as speedily as I can, given that I've got quite a lot to get through.
Well, don't worry about the time. We'll allow you what time you need. So where do we go from? Paragraph 3. Where do you want to go next?
So the paragraph that I'd want to take you to is under the grounds. So if we go to the substantive grounds, that is at 396, and that concerns first of all the frustration of the statutory purpose. We said if you go to 68 that that how the Secretary of State gives proper effect and promotes the statutory objective of Section 3C and the hostile environment is a matter for her. But in light of the above submissions, it's unlawful if the Secretary of State to act or fail to act in a manner that does not protect those whose leave is extended and protected by 3C and instead exposes them to the harmful impact of the hostile environment measures. So that was how we were putting the challenge to the failure to make that provision in the context of the Hadfield argument, and we similarly put it on the same basis in the context of the irrationality argument. As is clear from the claim form, it's the failure to make provision for a proof of lawful status for those who are on Section 3C leave. That has always been the focus of our challenge, and in the context of the submissions that are made specifically in respect of Section 55, they're at paragraph 94 at 406 to 407, and how that was put was that the Secretary requires the Secretary of State to make arrangements for ensuring that immigration functions are discharged having regard to the need to safeguard and promote the welfare of children, and sets out the case law, what's necessary to be done. And our submission was, in this context, that the Secretary of State was in difficulty because, as we'll see from the Secretary of State's pleadings, the position was that there was no engagement of Section 55 because there was no function. So there was never an acknowledgement that there was a duty or a problem. But essentially, what we say at 95 is that in the arrangements that need to be made for ensuring that immigration functions are discharged, taking into account the best interests of the children.
You mean 94?
94, sorry.
Okay, 94.
That simply had not been undertaken. It's common ground now that in making those arrangements for provision of proof through a digital means of lawful status is a function. That's not in issue now. It was in issue up until the oral submissions of Mr. Malik in the hearing below. And it's clear, we respectfully submit, that the focus of that challenge was to the arrangements that had meant that all those on 3C leave had not been afforded any digital proof of status. So there's nothing unclear in my respectful submission about the pleading and the basis of the case. what is problematic, we respectfully submit, or what has caused the difficulty in this case, is the way in which the Secretary of State responded to that case. We've heard for the first time some description as to how our pleadings were understood, which I've never heard before. But the bottom line is the paper speaks for itself. And if you look at the Secretary of State's consolidated detailed grounds of defence, which are in the same bundle at tab 19, page 240, in respect of the PSED argument, the position that the Secretary of State took, you can see it at beginning at paragraph 42. He said,
Sorry, no, just this is, you said the PS.
sorry, I'm
said you meant-
sorry,
you meant
this
section
section 55 GT, I
So
apologise.
paragraph 42.
Yes, so the detailed grounds begin at 225 and it's 240 under the heading section 55. And how it's prefaced is the short answer to this ground is that extension of leave to remain by section 3C of the 1971 Act is automatic in the specified circumstances, and it is not triggered by the exercise of any function by the Secretary of State.
Can I just to make sure I've understood this point, just clarify. So what Mr. Malik was pleading here was that in response to your pleading, and there's no in the pleading that you're pleading, you hadn't identified any function, had you?
We had identified arrangements, the making of the arrangements.
Had you? We
That-
just looked at
that's-
that. So sorry.
No,
So sorry.
well, just
And
Just-
the
complete your point.
we had set out the primary criteria in section 55(1) about the making of arrangements. Obviously, the section 55 argument comes at the end of an extended pleading in which we've made it clear from the outset and throughout that what we're complaining about is the failure of the Secretary of State to make provision for a means of proof if you're on 3C leave. It's as simple as that. It wasn't complicated. It's become obstructed or made complex by my learned friend submissions. It was absolutely clear what we were saying about the focus of our case. What was in issue up until the oral hearing was that Mr. Malik's position and the position of the Secretary of State was that there was no function at all engaged here because he simply focused upon the individual decisions to extend leave, rather than what we were challenging was the Secretary of State's position as a matter of policy at a general level, not to afford state a proof to this category of person.
So your case is if we read the pleading as a whole, as we should, your pleading, it is clear that you were asserting that there was a function for the purposes of section 55.
Yes, and it was conceded by Mr. Malik in oral submissions and is conceded today. But the claim that we were having to meet, or the response that we were meeting up until those oral submissions, was there is no function here at all.
Yeah. So you say it's clear that we were asserting a function.
Yes, and I'll
The
show
Secretary
you.
of State denied that in the passage
Yes.
that you took us to, paragraph
Yes.
2, but subsequently conceded it in oral argument.
Yes.
Yes.
And it may be, while we've got this open, just to have in mind what the Secretary of State said about the digital status checking services. What the Secretary of State said at that point, at paragraph 46, was that the new plan and the rollout of digital services is not directly relevant to this judicial review.
That's the final sentence of 46.
Yes. And that's in a context where not only was the Secretary of State submitting that there was no function here engaged in section 3C, but as you will recall from the earlier submissions, his response to the public law challenges was that there's no discretion in play here either. So that had been the very stark position that the Secretary of State took, and I won't take you to it now, but it's also reflected in my learned friend's written skeleton argument to the court. And so much of what is now in issue in this case only really became clear at the point of Mr. Malik's oral submissions. And ultimately, what's important here is how the judge understood our case and understood what the implications were of my learned friend's changed position. And if I can ask you to look at the judgment, it's in tab 14. And we respectfully submit that the judge very clearly understood what our submission was.
Sorry, which reference did you give?
You haven't given us.
I haven't given you a reference yet. I'm going to take you to the particular paragraph. It's at in respect of section 55 particularly. What he sets out is our submission made up by Ms. Liu at 247 on page 164.
So these are the passages to which Mr. Malik took us earlier.
Yes.
Yep.
So it follows that in making arrangements to give effect to the statutory protection conferred by section 3C, the Secretary of State is required under section 55 to investigate and to what extent making people undocumented during their period of section 3C leave impacts on dependent children. So the case was very much clearly put on the basis of the arrangements that the Secretary of State had made for proof of immigration status, which had which needed to needed to take account of the protections in section 3C and how that was going to be implemented with regards to the impacts on children. So the position, the submission, which we respectfully submit is a correct position in law, was very clearly focused on the failure to ensure that the protections in section 3C were given effect to. And that is in a context where, as he goes on to record at 248, the Secretary of State's position had changed. Prior to the hearing, he had said they were not exercising any function in relation to section 3C, and so section 55 was simply not engaged. As I've said, the Secretary of State resiled from this position at the hearing and accepted, and we've seen this, but what the judge recorded is what we respectfully submit Mr. Malik said. That was the position of the Secretary of State, that in deciding not to provide documentary proof to all those on section 3C leave, he was exercising his ancillary administrative functions. So there you have the position given in the oral hearing as to this position of the Secretary of State, that there had been a decision not to provide it to all those on section 3C leave, and that is what the Secretary of State had done. The Secretary of State had decided, because it's the corollary of that, that instead there would be a staged or phased rollout, and that rollout did not include at the point of the hearing and of the pleadings that it would cover all those on Section 3C leave.
Is that right? Once you roll it out to people who are being granted primary leave, it will also be available to those people at the expiry of their primary leave.
Yeah.
When they, if they make an in-time application for further leave and are therefore on 3C leave. So, rolling it out to people on primary leave is also rolling it out to people on 3C leave, though not immediately.
Well, the judge is concerned with the position as at the date of the hearing. At the date of the hearing, it was clear that the Secretary of State had decided not to provide proof to all those on 3C leave. That is a fact. That was the position. That had not occurred. And as a result, there were obviously people like Miss Adjei and a number of others, a substantial number of others, who were suffering significant hardship as a result.
I don't want to push this, but just want to make quite sure I understand. In a sense, that's true, but it's a slightly misleading statement of the situation. Wouldn't a fairer way of saying it is, the Secretary of State has decided to provide documentary proof to all those on primary leave, granted primary leave over a period of 2 years, which will also benefit them when they go on to 3C leave at the end of that period.
Well, you can put it in.
Ignores what the actual policy was.
Well, subject to one document that I'll show you shortly. In here, the judge is recording what was said to him, and within that, obviously there is an alternative way of putting what the same phrase. If it's not all of those, it's going to be done on a phased basis. So within that, there is the necessary corollary that it will occur. It will occur on a phased basis. So, in my submission, the judge is A1 reflecting what he was told, and B is the correct position.
Yeah.
In fact, if one looks at what the Secretary of State's position was on this, the best place to look at it is in the Secretary of State's application for permission to appeal to this court, because the Secretary of State responded to the judgment in the following fashion. I think the easiest place to look at it is in your Lordship's judgment at paragraph 61, page 21, although the document's also in the bundle at page 63. And your Lordships have summarised what the position was, and you'll see under paragraph 2, last sentence, it's not the Secretary of State's policy that all those who are on Section 3C leave should be given immediate proof of lawful status by way of a document. It is practically impossible to take any immediate action in that respect. So that's what the position was, reflected what the argument was below and before the judge, and the extent of Malone and Friends' concessions, and it's what the Secretary of State told this court when seeking a stay and permission to appeal. It then goes on to explain that there will be a rollout on a route-by-route basis, and that there is a plan to digitise all routes, excluding asylum seekers and visitors. So Malone and Friend has explained, A, the Secretary of State's policy, and also what the plan was, and that it's the Secretary of State's policy and plan in its submissions to this court about why the declaration that was made should be stayed. So whatever is now being said we respectfully submit, up until this court was on the material before this court, and the learned friend has not decided to, or the Secretary of State's not decided to put in any further evidence, the clearest position that the court has as to the policy and what we could call it the plan, both of which are documents underpinned by decisions that are for the Secretary of State and have been taken by the Secretary of State. And we respectfully submit that in those arrangements for the policy and the plan on digitalisation of proof of status, it is common ground that the Secretary of State has never had regard to the best interests of the child and has not discharged the duty under Section 55. That is the Secretary of State's position. The case that is advanced was, and still is advanced, is that Section 55 is not engaged at all. The only alternative submission that had been made was that it's discharged through the issue of the guidance, and there's clear authority now from DM that that is wrong in law. I'll take you to that when I do my legal submissions. But we are in the category of case where there clearly is a policy that was taken. It's a policy of the Secretary of State, and it is common ground that the important duty under statutory duty under Section 55, a mandatory relevant consideration, what is the impact on children, has not been addressed. The focus on investigation and consideration is a right one, because you can't properly identify if there is an adverse impact on the interests of children and what the best interests are if you don't investigate and identify the problem. Although in this context, as the judge rightly found at paragraph 191 of the judgment, the Secretary of State was on notice of very significant adverse consequences of not having a proof, an effective proof of your status from the Windrush scandal and from the evidence that had been provided by Ramphel itself in a report. He finds that the Secretary of State was well aware that there was a problem, but that problem was never factored into the formulation of policy on how the extension of digital proof of status would be rolled out. And we respectfully submit on that basis, it was clear, and the reasons that the judge gave at 250 are correct. There's obviously a longer response because I've got additional questions to answer. But what I want to take you to is to the new plan. The learned friend says, well, you've never challenged that, and you've never challenged the rollout as a particular focus. We respectfully submit that it is obviously implicit within the focus of our case on the failure to provide proof to all those on 3C status that we are concerned with the policy and the new plan programme. That became absolutely central once the Secretary of State's position had changed in the oral hearing, and that's why you will have seen that there was additional submissions that were then made following a request by the judge for further information. And it's important to look at that because in that, you haven't seen that document, but in that context, we made detailed submissions about the rollout, its implications, including for Section 55.
Which document you talking about?
So, my lord, it's in the core bundle. It's the submissions that came post. It came post the hearing. Sorry. It's in the supplementary bundle, my lords, going at 203.
When you say the supplementary bundle,
So that's the supplementary materials bundle
For this hearing? Or
for the original hearing.
Page 203.
It begins at 203. And what
So
happened?
this is a letter from Brent Murphy.
That is a letter from Bat Murphy where we sought clarification from the Secretary of State on information about the routes. Further information, we'd already made a Part 18
we've got some
request.
submissions.
And my submission is that that in response to that information, which you'll find at 205 to 206, we made detailed submissions which begin at 207.
Right, so do we start by looking at emails? Is that what you want us to look at?
I think you can probably, this is the first document is simply a request for information. And I think you can probably just look at the submissions for the purpose of the argument.
So that's 207.
And that's at 207.
Which particular bits?
So just first of all, you'll see at 2, this is the Secretary of State's response to the judge's question to identify the categories who had an e-visa already. And there were 23 categories and 66 did not. So the Secretary of State did not provide any information as to which those categories were, but we were able to do so to the extent that we could. And we made submissions in respect of it at 209, paragraph 11 onwards. 11 just deals with the request for information. And we make the point over the page at 210 that the information that the Secretary of State had given is the process by which we sought to obtain that information. We note that it's incomplete.
So where are you reading from?
It's
now?
the top of page 210:11. So that's just setting out the evidential position and the fact that the Secretary of State had declined to provide it. And we note that this data is relevant to the 2 procedural grounds, including the Section 55 ground. We said at 12, there is clearly a conscious decision taken to extend e-visas to certain categories, but not all of those who will need to rely on 3C leave. This was an exercise of discretion and a function to which the duties under Section 55 apply. We identified then what was already the evidence before the court about the differential.
Sorry, just to be clear about this, this worries me. The first sentence, to extend e-visas to certain categories.
But not all of those who need to rely on 3C.
But hang on, but they're not categories at all, are they? People on 3C leave. The decision was to extend visas to all categories, but not straight away.
Yes.
And separately, not to give it to anyone who is already on 3C leave.
Yes, we're making the point here.
Okay, that's fine. I just want to make quite sure I'd understood.
Yes.
Understood what
So what was then obviously apparent and clear was that there had been a conscious decision. This is the rollout, and that we said that was a function to which Section 55 applied. We then identified how there had been differential adverse impacts, and you'll see at paragraph 13 that how we said that had implications for this Section 55 argument. So if the court could read 13 and 14. And in about 5 lines up at the bottom at 13, we identified children as one of the groups that were disproportionately adversely affected on our evidence, and identified some of the groups that would obviously directly relate to children. And then we undertook a 211 to 2140 what we understood then to be, and it's the groups to which the rollout had not been extended. So the court will see that it includes within it significant cohorts of categories of person or route of immigration leave that would inevitably include children.
But to what point that's an issue on this hearing does all this go?
Well, it goes to the discussion that to Malone Friends' submissions, that what's the focus of our case, and that we never identified and challenged the new plan and the rollout.
Yes,
We did it, but we only did it at the point at which it became material, because the Secretary of State was now adopting a very different position than the one she'd taken in the pleading,
Okay,
which
so
was
this
no
is post-concession, post
Yes.
what the judge summarised in paragraph 248.
Exactly, my lord.
Just some of the detail you were giving seemed to me to be irrelevant to that point.
Well,
But I get your basic point that at this point you're focusing on the rollout.
Yes, because
But whether it included this or that group is really neither here nor there for that fundamental point.
no, but it is relevant. That's the fundamental point, but it is also relevant when it comes to looking at the impacts on children,
You say that
because the
analysis
groups,
illustrates the section
yes,
85 group.
because the groups that were not included in the rollout included significant forms of leave where it's inevitable that children are involved either directly or indirectly. And just by way of example, Appendix FM, that's the route by which Miss Adjei had obtained leave. That's what's called the 10-year route to settlement, because if you don't meet the financial requirements, you're on it for 10 years. So you're the group where you're more times on 3C leave and for longer periods, and the evidence is in the judgment, because even the Secretary of State's own target time is 12 months to decide Appendix FM claims. That's why Appendix FM people form a significant proportion of the Ramphel cohort, because they are materially at risk, greater risk of adverse consequences of not being able to prove their status when they're on 3C leave for the longer periods and more occasions.
Right.
But that's one of the groups, but you'll see it also included victims of domestic abuse. Bereaved partners includes dependent children. Appendix private life, that's children who've been living in the United Kingdom for longer than
I think you've
7
probably
years.
illustrated.
I hope I have.
I mean, you can go through
Yes.
other minute examples,
But-
specific examples, but I think
Yeah.
we've got that point.
Yeah, the proposition is that the Secretary of State's arrangements for giving effect to her policy on the extension of digital proof of status did not take account of the fact that there were going to be, on the groups that were not included in the initial phase and only in the later rollout, were inevitably going to include significant numbers of
Well, I
children.
think, as I said, we've got that point.
I'm grateful.
Now, where do you want to go next?
So where I want to go next is to the new plan, and what I would be inviting the court to do before I do that is to recognise that the submissions that my learned friend made extensively on the matters not having been advanced before the court below is incorrect. And it's in that context that then you understand the judgment of Mr. Justice Kavanagh and how he approached the questions that were before him. So then, looking at the new plan, my learned friend says we haven't addressed it. I've told you why we do. But what's significant about the new plan is that it is the arrangements, or part of the arrangements, that the Secretary of State has made to provide proof of status, and it is a policy that has been formulated at the highest level by the Secretary of State, and we can see that if you take up the additional bundle.
For today.
Yeah, the additional bundle. We'll just look. I hope as briefly as I can. We've set it out in our submissions.
So we can put away the old supplemental bundle.
Yes, yes.
We go to the plan for today. The plan for today. What tab number?
It is tab 7, page 61.
This is the exhibit to Mr. White.
Yes, and as you can see at 62, it was presented to Parliament by the Secretary of State for the Home Department.
So this is a publicly available document.
Yes, it is. Yes, and it's the Secretary of State's policy.
May 21.
May
so
2021.
Before the
That's right.
proceedings were issued.
Sorry, my lady.
It was issued before the proceedings were issued in this case, is that right?
Yes. It was October 2022 for Miss Ramphal and Miss Adjei, and for Ramphal it was February 2023.
In fact, Miss Adjei didn't make a section, didn't plead a section 55
She
case.
didn't. She didn't. But it's in a consolidated claim.
Once Ramphal came on board, she adopted it.
Yes.
But the section 55 case is therefore first pleaded in early 2023.
Well, it's not as simple as that, because in fact it was pleaded in the Adjei case. It was, yes.
It wasn't pleaded.
It was.
But it's 18 months before the claim.
Yes, it is
Any
before the
claim.
claim. That's right. But what this document is setting out the broad strategy and the plan, and it expressly does so. You'll see at page 65 to 66 that. Sorry, at page 81. Sorry, it's a plan immediately for the period of 2021 to 2022.
Right. So we should be on page 81.
Yeah, paragraph 37. Hope. And what it explains is that they were continuing to deliver a digital system by removing the use of physical documents, and gave example of where that had occurred already, predominantly with EEA nationals, some points-based routes, and the British National Overseas route. And they say at 39 that we will be taking a phased approach as we move to a digital system. And we're looking for further ways to remove physical documents. And that what they intend to do is build upon the success of the EUSS, that's the this EU scheme, to do that. And that at 89, paragraph 51 onwards, they talk about our vision for border and immigration system beyond 2022.
Right.
And recognise at paragraph 69, page 91, that proving and checking an individual's identity is at the heart of our immigration system. So there's no question that they aren't alive to the significance of being able to properly prove your identity. At 77 on page 93, there's the long-term vision, so it's prospective, long-term vision about moving to a fully digital system, that's at 78. And at 79 is where it says that this service has been extended to EU citizens applying under the future system. It will be rolled out more broadly. So that is in the future. The rolling out more broadly is in the future. And it says at 82 that it will be...
Maybe we want 81.
Yes. 81 on page 94 and 82 is again setting out the route-based
The reason I refer to
process.
81 is it gives the dates.
Yes,
by the end of 2024.
by the end of
It
2024,
also
that's
gives
right.
the reason why the majority of physical documents currently held by individuals to evidence their status will expire by the end of 2024, by which time we plan to have a fully digital system in place.
That was the plan, yes.
But it also explains why that date has been chosen.
Because to implement it, it was that they were going to, nobody would have BRPs, the physical documents, digital, that would no longer exist. That doesn't address people on 3C leave because, of course, they have no documents at all. But it was about the rollout for replacing physical proof with digital proof. So that was the position in the new
Can I
plan.
just read 82?
Yes.
Do you have any submissions about the last sentence?
Yes, we say that the Secretary of State recognised that that the question of proof of status was at the heart of the Windrush generation problem. So they were aware that if you don't have proof of your status, there could be very profound problems. So it's on the Secretary of State's mind to refer to that. Obviously, she doesn't make any reference at all to those who could be in a similar position in terms of not being able to prove their lawful status.
Well, that's why I asked. Doesn't that category of person come into the last sentence? Isn't that, please tell me if I'm reading it wrong, isn't that saying, we learnt what from our experience with Windrush,
Yes.
and so people,
Yeah.
this must include 3C people, mustn't it?
Yes, they're not
Or
expressly
all
referred to,
the
but it
paper-based
does. Yeah.
documents.
So-
And we will avoid that situation by making sure they have access to online immigration status service.
Well, yes, they were alive to the fact that there's a problem. That's why, as I said, the judge concluded the Secretary of State had knowledge that that they could have significant hardships if you were not able to prove your lawful status, because you could be wrongly subject to the hostile environment which had happened to the Windrush generation. So it's not as if it's something completely out of that nobody could have anticipated. It was clearly an issue that at a high level the Secretary of State was aware of, which is all the more reason why, and it's not said, Learned Friend takes a pleading point and a time point, but the Secretary of State does not say that when she formulated this policy, she had in mind at all the duties under Section 55, although it's conceded that this was a function.
That's a non-issue. Nobody's suggesting that. It's not being said, we, as a fallback, we comply with the Section 55 duties.
Exactly, yes.
So, but why are you using valuable time making that point?
Well, only because obviously I'm going to, well, I've made the point, I won't say why. Maybe it's a bit obvious, but you're right, I'm repeating. That's not an issue. And this is accepted to be a function. So it's within the meaning of the legislation. We then have to consider a second document, and this is a new document that it wasn't before the judge below. It's in tab 8.
Do you need leave to?
Well, I don't think my learned friend objects. It's the Secretary of
Well, we
State's
still need
document.
leave.
If I need leave, I think we've
So
got
are you
more.
making an application?
Yes, if I need to. I think most of these documents, some of the yes, were not before the court.
Well, we do need leave.
Yes, if I need, I didn't realise it was an issue, but if I formally need leave to admit these documents, then I seek it now. But this would be a document that should have been disclosed in the Secretary of State's duty of candour in any event. But the more important point is that this is an update to the new plan in May 2021. We've addressed this in our written submissions. It's not new to the Secretary of State now. I'm not doing that kind of approach. So it's page 98, tab 8. This document is from the 25th of November 2022. And again, it's the Home Secretary document. You'll see that under contents.
And a publicly available document.
And publicly available document, yes. And so we've seen what the vision was in the new plan, and then we get some detail as to what that is then going to mean in practice in this document. For our purposes, the most important part of it is that it identifies for the first time the use of the word e-visa, but that's in a context where they talk about, again at paragraph 31, 109, delivering an end-to-end digital experience, and at 110 in the middle, living in the UK, further implementation of e-visas, giving users the ability to demonstrate their rights in the UK via simple online services. So this is a move on from where we were in terms of the decisions on which categories and the timing, obviously within the context of the December 2024 deadline, but you'll see the reference to e-visas at page 113. Paragraph 45. And again makes reference at 46 to the consciousness of the lessons learned from the Windrush, and are committed to ensuring that all our customers, including the most vulnerable, are properly supported as we transform it. So again, alive to the issue. And then if we go on to 122, it's talking about the introduction of e-visas. That's at 75 and 76. So this is the next phase in the process of identifying the categories of people or routes that will now benefit from the e-visa scheme. And we know from Mr. Wright's witness statement, which you'll recall in paragraph 13.
Where do you say it deals with the different categories and routes to which it will apply? I just missed that.
It doesn't set them out. It just tells us that that's what's happening.
Okay. And what does it take us to Mr. Wright?
Yeah.
Is this the passage quoted in paragraph 60?
Yes, my lord, I think it is, because it's in that Mr. Wright gives us the date for when this rollout was going to occur, and it was from the 26th of January. That's paragraph 13. So what we then can see is that we have this updated position. They're now rolling out, intending to roll out the scheme to particular routes. And what we know from Mr. Wright's witness statement is that it was intended to do so beginning on the 26th of January 2023.
Can we look at Mr. Wright's statement?
Yes, it's in the supplementary bundle,
yes.
Page 5, paragraph 13.
Right.
So which page? Page 5.
Sorry, my lord. Yes, 5, paragraph 13. It's about. This is obviously, it's retrospectively. The statement is 20th of September 2023. So he's talking about the fact that when the rollout occurred, obviously immediately preceded in November by the document that I've just showed you.
Now, which passage in paragraph 13?
It's about halfway down, my lord, and it's begins since 26th of January.
You mean
2000?
precisely, yes.
Second half.
26th of January 2023. And explains the e-visa process. Obviously, that witness statement didn't give any detail at all about the routes.
Well, it does say it does explain, does it not, or provide some explanation for how this was going to be put into effect.
Yes, it gives it does. It confirms that there would be a rollout and arrangements
Someone
had
with an
already taken
existing
place.
e-visa who submitted an in-time application
Yes.
will be issued with evidence e-visa if application is successful.
Yes, but what is subsequently clear as a result of further information that was obtained in the second witness statement and as a result of the judge's questions was that this hadn't applied to everybody. It had only applied to the 25% of categories that it had been rolled out to.
Very clear about that factually, but I haven't understood why that affects the exact issues before us.
Well, my lord.
That it was some routes and not others.
Well,
the problem would be the same if it had all been done at once.
Well, the reason why it's relevant is because I'm responding to the submission that we never identified the rollout as part of the context in which the Section 65 duty had to be discharged. But it's relevant for the reasons I've already showed your lordship, is that there was a conscious decision, as we said in our post hearing note that I've showed you, to roll it out to particular groups, and the ones that were not included, by definition, were bound to include large numbers of vulnerable
But even
children.
those who were included, it wouldn't help those who were already on 3C leave, and that's your real complaint. That's the point I was making, Mr. Mallett.
Well, we
You would have had a complaint
Yes.
if this had not been done gradually.
Yes, we did complain about that.
Yes, but just conceptually.
Yeah.
It's just icing on the cake that it took 2 years. You have a complaint anyway on day one of your claims
Yes.
that people on 3C leave
Yes.
are not going to get this until, at best, the expiry of any e-visa which they may be granted.
Yes.
Yeah.
That is our primary case.
Yes, okay. Okay, I don't want to go on. Time is short. I just want to make quite sure that I've understood that correctly.
Yes.
Yeah, okay.
But let me just put this in this context, is that when it comes to the application of the Section 55 duty, one of the things that the Secretary of State could have considered, had she considered it, which she hasn't, is, well, okay, I'm rolling this out. I can't do it to everybody, but can I focus on groups where children are more likely to be affected? Because I know there's evidence from, say, for example, the report that Ramphel did, that single women with children are being particularly adversely affected. And my lord, it's here, ultimately, that you get to the relevance of what ultimately has been part of the reason why you have overturned the judgment below. Obviously, because the groups that are adversely affected most significantly are these particular groups. So that's why the evidence before the court, even if it couldn't describe the whole situation, of course we couldn't, we could only provide the material from our caseload on Ramphel, and what was evident and what the judge recognises is that there are particular cohorts that were particularly at risk of being wrongly subject to the hostile environment and at risk of adverse consequences. And so that's why we respectfully submit it is relevant to look at the rollout, because that could have been a mitigation.
While we're
For
on
example.
this paragraph of Mr. Wright's statement, paragraph 13,
Yes.
what are your submissions on the last sentence? Which is relevant to relief.
Yes. Well, the submission that we make on relief is that first and foremost, on the Section 55 duty, it's not open to this is a policy that's been formulated without having regard to that possibility. This is a policy that has been formulated without complying with the duty under Section 55. So whatever the Secretary of State says about what can and cannot be done, that conclusion was drawn without looking at the impact on the best interests of children. So that would be our first proposition. And the second proposition really is the one that I've just made to my Lord, which is that even assuming that you couldn't do it retrospectively for those on 3C leave, you could have mitigated the impact on children by selecting different routes and giving priority to the routes that were likely to be concerning children and also likely to be vulnerable children. So the court has treated that as a fundamental problem on the irrationality challenge, but it isn't one when it comes to Section 55, because first you have to identify the problem. Secretary of State hasn't done that. Then you have to think about ways in which you could mitigate it. It's a bold statement that it can't be done retrospectively. It's not clear if that's because that's the policy decision that the Secretary of State has taken, or if there is some practical reason.
That's the evidence.
There isn't a practical reason that we're aware of.
But the evidence is that it could.
Yeah, well, let's assume that it's that. But it's not the end of the matter for Section 55, because you can look to see how can we mitigate this. And the obvious option was to prioritise different groups than the ones that you did, or do it quicker. See if you can speed it up, or even the other mitigation could have occurred. Don't leave those on Appendix FM waiting for over 12 months, often 18 months for a decision. There are different things that you could do. You could prioritise the determination of their claims so that they aren't on Section 3C leave for so long. It's obviously in this context, it's a procedural duty. It's not for us to identify what mitigations could occur and then for the Secretary of State to knock them down. The Secretary of State is the relevant body with the statutory duty, and there are options, and they were just never addressed because, as is common ground, that obligation was never taken into account. So what we say about the new plan and the consequent updating position and its rollout is that, contrary to Malone and Friends submissions, this is firmly within the rubric of our claim. So there was a broad policy position taken in May 2021. It was given further content in November 2022 and implemented on the 26th of January 2025. And so if you're looking at claims that were challenging the consequence of that policy, i.e. the failure to provide digital proof of status to those on 3C leave, and I accept we focused on the consequence, but that's what we were focusing on because that's what we were complaining about. If you look at it in that context, claims that were brought in October 2022 and or February 2023, there's no problem here. It's all within a reasonable time frame for challenging those policy decisions. And the fact that when we issued our claim, we didn't do that, I've sought to explain to you why. Because we were dealing with a case that the Secretary of State made. But it's very clear from the note that I've provided to you, and I'll come to it now, the judgment, that the judge addressed that issue in the case, the way we put the case properly below.
Right.
So if I'm going on to a new topic, which is to look at the judgment. I don't know whether it would be better to come back at 1:55.
Which is 11.5 days. We had how much longer are you going to be?
I would think I'll probably be about another half an hour.
We have a half time. I didn't note I didn't ask you to divide your time. not learnt the lessons I should have.
Sorry,
about chairing hearings. Are you so you've got another half-hour submissions?
Yes. Yeah.
So a word. Are you able to? And then you've got to reply.
I'm in a professional difficulty. I mean, the time estimate for this hearing was half a day. I'm in the middle of a 7-day hearing before the Upper Tribunal's presidential panel. Because of this hearing, of course, the judges allowed me to attend this hearing. But I'm back before the presidential panel, I'm afraid, at 2 o'clock. Today's day 3 of that.
Yeah. Well, we've got to carry. I think, Ms. Harrison, I didn't make a note of when you stood up, but I think you've had more than half the morning.
Well, my lord, I can only say this, is that I didn't anticipate that I was going to have to take the court back through the way the case was put below. And
well, I don't have a big post-mortem about how you've conducted the case. I've got no criticisms of how you've conducted the case. This is not a straightforward point. But I would urge you to be as prompt as you can now. We're going to sit on. I'm sorry, conscious to start.
and can I just also say that I did ask that wasn't what Mr. Malik told me this morning about his position. Otherwise, so I did ask him about that. So not that what was his, because he explained that. So I haven't sought consciously to put him in a difficult position.
Let's carry on, but please. If I can urge you probably to
Yes.
be as quick as you can, and we will be restrained in what we intervene with.
Well, my lord, what I think I'll do then is probably the easiest thing is to deal as briefly as I can with my legal submissions on section 55. I've dealt with, I hope, in showing you that sequence of policy decisions, the who, where and when,
Yes.
that you have that. The only point that I do have to make is that it is not acceptable for the Secretary of State not to provide clarity in a witness statement about that. The fact that the Secretary of State has not done so is that you're entitled to draw inferences from the documentation. The inference that I would invite you to draw is that it's the Secretary of State for the Home Department who is responsible for the policy positions that you've seen, and that there isn't and that would by necessity include decisions about which routes to roll out when and whether to include those with Section 3C leave, and remind the court, as my learned friend put it in the application, it's not the Secretary of State's policy to provide all those on 3C leave with digital proof. So that's the evidential position that the court has. It's a policy decision taken by the Secretary of State. And that's important.
It's not the Secretary of State's policy to do it immediately. But in due course, they will get digital proof.
Well, whichever way you look at it, and whatever that policy means, and I've sought to explain what that is, it's the Secretary of State who's made that decision on the evidence that the court has.
I wasn't challenging that, I was challenging the way you put it. Anyway, it doesn't
Sorry,
matter.
I'm trying to shorthand, but
Yes.
but ultimately, what we say is the position is that that the Secretary of State has formulated the policy, and it's common ground that in formulating the policy on who gets e-visas and when, that is common ground to be a function within the meaning of section 55, and it is in exercise of the ancillary functions, administrative law functions, that we know that the Secretary of State was exercising pursuant to the explanation in the New College case. And what we do say about that is that insofar as these arrangements are ancillary functions, they are the functions of the Secretary of State. That is clear from the New College case.
Okay.
That you'll recall that from paragraphs 27 to 29.
No.
Yes.
I don't think this if I may say so, these legal points are going to be controversial.
Well, I'm grateful for that, but the point that I make, which is significant, is it's the responsibility of the Secretary of State, not an immigration officer, to exercise the powers that are incidental to the functions under the Immigration Act.
Thank you.
Immigration officers only have power if expressly conferred by the statute.
Yes, but there are loads and loads of officials in the Home Office and, you know, Carlton and all the rest of it. A lot of this stuff will be done by officials, not by Secretary of State personally.
Well,
That's the point made in DM, is that there's a distinction between decisions taken by ministers
yes.
and decisions taken still in her name, not by immigration officers, taken in her name under the Cartel principle. One's under 55.1, one's under 55.3. I don't want you to hint all this, except that you've raised it.
The point that we're making is that these particular functions that we're concerned with have a particular route, because they're not statutory functions, as we know from from the New College case. They are functions that are incidental to the Secretary of State's powers.
The fundamental point, which I understand, is these sorts of decisions must be made by ministers.
Yes, yes. And in terms of the duties under Section 55, and I'll take this as quickly as I can because I think it's not controversial, and I'm relying upon the judgment of the Court of Appeal in the PRCBC case, and of course DM, and I'll take you to DM afterwards, but if I can just deal with it speedy as possible. So Section 55(1) is a positive duty. It is a duty on the Secretary of State that may be exercised by ministers. That's made clear in the PRCBC case at paragraph 70, little 3, and in DM at 84. It's also a mandatory duty. The Secretary of State must. That's in the legislation, and as was particularly emphasised in the DM case, it is a duty in the making of arrangements, and that's for specified purposes. Here we're concerned with the arrangements for proof of immigration status, and is a process duty concerned with the requirement to take into account in the decision-making process, and applies to the role in setting policy, and that is a personal decision of the Secretary of State. Again, that's clear from DM 67 to 68 to 69, and it's obviously clear that the fallback argument that my learned friend advanced before the court below, having conceded that there was a function here engaged, that the arrangements are limited or discharged by the issue of guidance, that is clearly wrong. That's PRC BC paragraph 70 little 3, and in DM at 69 and 128. The position is that in discharging this duty under section 55(1), the Secretary of State is obliged to have conducted an exercise that ensures that her policy on digital proof of status had regard to the best interests of children. And it is common ground, as we've said, that the Secretary of State did not do so. We say that it's clear from the policy or the guidance, Every Child Matters, that it is only concerned with the decision of immigration officers making individual decisions. It's UKBA, now the Home Office. And so the primary fallback argument is roundly rejected in the authorities. And that what we're here focusing on is the arrangements. We're concerned with arrangements in the exercise of the Secretary of State's powers. They include subsidiary legislation, immigration rules and policy, and it's common ground that they also include the incidental powers. That was the judge's finding in the judgment of paragraph 112 at page 124. We do say that that we have been able to identify what DM says is necessary, paragraph 106 on page 228 of a substantive act. As I've shown you in looking at the documents previously, that there is clearly a substantive act that the Secretary of State has undertaken. We're not here being concerned with requiring the Secretary of State to reconsider the position or to make a new policy. We are clearly in the same territory as the DM case at paragraph 128. The Secretary of State has made decisions, has adopted a policy between May 2021 and January 2023 on the position with regards to those on 3C leave and digital documents. And so the 4 points that my learned friend referred to are not determinative of this case. We say on all fours with DM because you have a policy decision taken where the Section 55 duty was never considered at all. That is, in that respect, an ongoing breach. And that's how we described it because it's never been remedied. So the concern that the court had and rejected in the first part of the argument doesn't apply to this case. And we aren't simply relying on the operation of a system, we are relying on specific decisions. And the stark fact is that the duty has never been discharged up to and including the date of Mr. Justice Kavanagh's decision below. We say that the duty clearly does arise in the context of this case, where you're concerned with children who are both potential applicants for leave to remain, who then are on 3C leave, or where they are dependents on the claims of people with 3C leave. So the point that that the court raised about what does affected mean in this context, we say that it's quite clear on the evidence that the decision and the policy about implementation of proof of status concerns children, either as applicants or dependents, and that they are affected by the decision. We rely on what's said about that in my learned friend's skeleton argument. He accepts that the application of the best interest principle means that the kind of impacts that we have here on dependent children falls within the duty. And by reference to what's said in the statutory guidance, that's in paragraph 12 of his submission. So although that was raised by the court as a concern, we say that the evidential findings of the judge below in a number of ways about the ways in which children would be adversely affected, and that I'll give you the paragraphs, it's 103, 199 and 250, that there's no difficulty with recognising that there are adverse impacts here on children and that the best interest principle therefore needed to be addressed. We do say that it's for the Secretary of State to demonstrate that the duty has been discharged. Unlike the context in irrationality, the Secretary of State has the duty and needs to demonstrate it by evidence. And so the deficits in the evidence shouldn't be to the...
Sorry, this isn't an issue, is it? He's not saying that I was under a duty, but I've discharged it.
That's correct.
So why are we being addressed about this?
But only on the basis that insofar as my learned friend does make submissions about the absence of evidence, this is a context in which the burden is upon the Secretary of State. That we say that's a matter of a generality, and insofar as the court's role is concerned, as is clear from PRCBC 71 to 72, because it is a process duty, it's not for the court to carry out the balance or engage in the merits. The judge made that point at 250. It is a matter for the Secretary of State. And in terms of, I've addressed the reason why it's not, there's only one answer here, put to my Lord Justice Baker about the paragraph 13 of Mr. Wright's witness statement. It can't be retrospectively done. I've addressed you on why there was an issue still to be addressed by the Secretary of State. And in terms of, is it an academic argument now? First of all, we respectfully submit that in a process case where the Secretary of State has not discharged that duty, it's important for this court to make that clear, even if it's now only of historical significance, if that were the case, because these are important duties, and it's too easy for the Secretary of State to say, well, it's too late now, we can't do anything about it. And she says that in two ways in this case. She says it, well, we can't do a different rollout. It's already been done, and it would be too difficult and too onerous to change it. And it's now been achieved. In respect of the first proposition, if that were an answer to cases such as this, well, we formulated our policy, we've implemented it, so court's role function is, it can't really do anything about it, it's a matter of practicality. That is entirely contrary to the statutory purpose of duties like the PSED and Section 55, which is to ensure that these particular considerations are always taken into account in appropriate policy decisions and in the arrangements that are made for, in this context, immigration functions. And so it just encourages the devaluing of this important procedural obligation. And insofar as we, the argument that, well, because we didn't succeed and you've overturned the judgment on irrationality, that must therefore follow also on Section 55. We say that is clearly a flawed approach. It's one thing to say that a policy is not, it was rationally open to a decision maker, and another to say, but in formulating that rational decision, the Secretary of State did not take into account a mandatory relevant consideration in circumstances where, had they done so, it could certainly have resulted in different steps being taken. But ultimately, even if it didn't result in different steps, the point of this duty is that it is addressed, and the Secretary of State satisfies themselves as to why there are no alternative mitigation, different measures or mitigation. And so we say that it's not consistent with the nature of this duty and the court's function in ensuring that decision makers, the Secretary of State properly discharges it, to either treat it as there is no alternative and or that it's now academic. And insofar as the fact of whether it is academic, we have made the observation, and I think in our case, that in fact, because the rollout was extended beyond December 2024 and to June 2025, the numbers of people who are still adversely affected by this policy position, your Lordship said in the judgment, paragraph 24, that it could continue until May 2027, if you recognise how it applies in practice. In fact, that's likely to be much longer, because ultimately the rollout has been extended, and certainly to June 2025. But even if it was only May 2027, there are still people today on 3C leave who are at risk of wrongly being subject to the hostile environment, which neither the Secretary of State nor Parliament intended. And in those circumstances, my Lord, my lady, that's a further reason why you should reject the proposition that this has become an entirely academic appeal. If I just, for those reasons, we'd invite you to uphold the judgment of the court, paragraph 250, that there's no misdirection in law. The judge properly considered the evidence on this matter, and he came to a clear conclusion that is supported by the authority.
Milady has a question.
Yes.
Yes, I'm sorry, Ms Housen,
No.
I understand your submission that 4 points which Mr Malik extracts from DM are irrelevant. I've got that point. May I ask you please, do you accept that those 4 points are an accurate summary of what those bits of DM decide?
I think I'd want to put it this way, is that I accept that it is not a continuing duty.
No, I don't want you to reformulate it. Just tell me whether or not you agree with that those 4 points can be discerned from DM, and if you disagree, please tell me which points aren't in the DM judgment.
I don't disagree with the description of what's said in the judgment.
Thank you.
Thank you. Ms Harrison, thank you very much. And to Ms Lutu, I'm very grateful to you for completing your submissions in less than half an hour.
Yes.
You warned us about. Thank you very much. Mr Malik.
My apologies for all the inconvenience. Just one short point in reply. So you recall that Miller and Friend took you to her submissions made to the judge after the judicial review hearing.
Yes.
Page 207 of the supplementary.
Do you want us to have that open?
No. Miller and Friend has shown you that in that document, the respondents stated that a conscious decision was taken to extend e-visas to certain categories, but not to all those who are in Section 3C at once. That decision, it was said in those submissions, was an exercise of function under Section 55. But the judge has not held that decision, assuming that there was such a decision, was made in breach of Section 55 and was therefore unlawful. The declaration that the judge has made is not that in making that decision, the Secretary of State has failed to have regard to the Section 55 duty. Now, Miller and Friend is challenging, it's clear from her submissions, the 2021 policy paper and the sequence of the rollout pursuant to that policy paper. The judge has not made a decision as to the legality of that policy paper or the sequence of the rollout. And in absence of a respondent's notice, in my submission, the court should focus on the reasons given by the judge for his decision and for the declaration that he ultimately made. If the court is persuaded that those reasons are wrong and the declaration is wrong, the appeal should succeed. It would not be appropriate in my submission for the court in this appeal to embark on considering whether the 2021 policy paper was unlawful or whether in setting the arrangement for the sequence of the rollout, the Secretary of State had acted unlawfully.
Thank you.
Very good. Thank you.
Thank you both very much. Well, we're going to reserve our judgments on this supplementary issue, round 2, which you'll receive in draft form in the usual way, to provide you with an opportunity to correct typographical and other minor errors, obviously not to re-argue the case. Please bear in mind the rubric at the top and a warning about contempt of court if the document is disclosed to anybody other than the persons to whom we have. It should be authorised under the information we've been given. be grateful if you would, on receipt of our judgment, draft the order which reflects our decision. If there's any ancillary issue which remains outstanding, we will resolve that on the report.